everybody, if you can't follow the rules in jail, then it doesn't give me a lot of confidence that you're going to be able to follow the rules on probation.
Excuse me.
Good morning. Are you Ray LeBlanc?
Yes, ma'am.
Can you hear me okay like that?
I can hear you.
Okay. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. LeBlanc, in cause number 250460, you're charged with the state jail felony offense of burglary of a building from February 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
Okay.
You're a U.S. citizen.
Oh, yeah.
Okay. I have to ask everyone. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
Because of the judgment entered against you, you're in.
This may sound like a routine courtroom exchange, but legally this is one of the most important parts of the process. The judge is making sure the defendant is pleading guilty voluntarily and fully understands the consequences if someone later claims they were pressured or confused. The entire plea can be challenged in court.
Eligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices. I'm required to read it to everybody.
I've never owned a firearm in my life.
I got to say all these words, sorry. So you should read that to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Okay.
Good luck to you, sir.
Thank
you, Ms. Holmes.
Yes, ma'am. Thank you.
Hubert?
Yes, ma'am.
And Mr. Jubert was previously in court, entered pleas of guilty in cause number 25 DCCR 1130 to unauthorized use of a vehicle, a state jail felony, and in cause number 25 DCCR 1131.
The firearm warning might seem repetitive, but in felony cases judges are required to read it out loud even if the defendant says they've never owned a gun. The court still has to officially explain the restrictions. It's all about making sure there's no confusion later about what the law allows and what it doesn't.
And to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review it?
You have, Judge.
I have, Judge.
Are there any additions or corrections?
No, Judge, not at this time.
Only that the state concurs with the recommendation of IS of cognitive judge.
All right, thank you, Ms. Malfino. All right, Mr. Jubert, I am
Here the judge is focusing not only on the original charges but also on the defendant's behavior while in jail. Incident reports matter because they show how someone responds to rules and authority. The judge is basically saying if small rules can't be followed now, probation could become a much bigger problem later.
So, Mr. Jubert, I know you know this already because everybody out there knows that I get the jail reports, right?
Yes, ma'am.
So there was an issue pretty recently. You haven't had a lot, but just recently you had, earlier this month, one about a mattress, right?
Yes, ma'am.
and you weren't very respectful about what you said to that officer when they said for you to give up one of those mattresses, were you?
Yes, ma'am.
So it's the same thing that I say to everybody. If you can't follow the rules in jail, then it doesn't give me a lot of confidence that you're going to be able to follow the rules on probation.
This feels like the turning point of the hearing. The judge is giving him a major opportunity through deferred probation. If he successfully completes the program, could avoid having a felony conviction on his record, but if he violates probation, those prison sentences immediately become very real.
Does that make sense?
Yes, ma'am.
So part of this agreement, or part of the recommendations in this agreement, is for me to go along with giving you probation, but send you to the ISF program, the cognitive track, which is a program to help you make better decisions. But I want you to understand, if I follow along with this agreement and you get any more incident reports, either here or at ISF, it's going to be a violation of your probation, and you may never get out of jail before you violate it. And I know you've been out there long enough to know that I've done that already, right?
Yes, ma'am.
Okay. So then what I'm going to do, Mr. Joubert, is give you this opportunity. I'm going to find in each of your cases that you entered those pleas freely and voluntarily. In cause number 25, DCCR 1130, find sufficient evidence to find you guilty, but I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay a $500 fine in that case, and to follow all of the rules and conditions of probation. And then in cause number 25, DCCR 1131, also find sufficient evidence to find you guilty, but follow the agreement and defer all proceedings for 5 years. You're ordered to pay a $300 fine in that case, and to follow all of the rules and conditions of probation. One of those conditions in each case is, again, that you enter and successfully complete the cognitive track of the ISF program. Also, there's going to be you're going to have a couple of assessments done just to see what all probation needs to offer you so that you can be successful. There's going to be a mental health evaluation, substance abuse evaluation, and if there's anything in those evaluations that say that you need...
The atmosphere in the courtroom changes completely here. Sexual assault cases carry consequences far beyond prison time. That's why the judge is carefully explaining every right being waived, the possible sentence, and long-term consequences like sex offender registration. The court wants to make absolutely sure the defendant understands what's at stake.
Some further treatment for whatever it is, then it is going to be your responsibility to do that and part of your probation. Do you understand?
Yes, ma'am.
You're going to get all the tools that you need to be successful. You're young, you don't have felony conviction on your record right now. If you successfully complete these probations, you will never have a felony conviction. This is a great opportunity. But the other side of that is, if you violate any condition and you don't take advantage of the tools that are going to be given to you to be more successful, you're going to be right back in here in court. You're going to be looking at up to 2 years in a state jail prison in one case, and between 2 years and up to 10 years in prison on the other. You understand?
Yes, ma'am.
Again, I want to make sure I reiterate how important it is not to get in trouble in jail while you're waiting on ISF, and not to get in trouble while you're at ISF. If other young men are out there acting up, you need to say, look, I want to see the light of day again. Y'all go do what you're going to do, and I'm going to today sit on your bunk when you're supposed to sit on your bunk. Don't sit on it when you're not supposed to. Have whatever you're supposed to have. Don't have extras. Just follow the rules. And if you're called out for not following a rule, don't get mad at the person that's calling you out for not following the rule, right? You're the one that's not following it, so don't get mad at them, okay? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, so you have waived your right to appeal. Good luck to you, sir. I hope you do well.
Thank you.
Good morning, sir. Are you Derek Ardwan? And will your client waive the formal reading of the indictment?
He does.
Mr. Ardwan, in cause number 250350, you're charged with the second-degree felony offense of sexual assault, and that's from July 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I accept this agreement, you're leaving your punishment up to me, and I cannot give you more than 6 years. I could give you 6 years, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and determine two things. The first is to decide if you're guilty or not, and then
And the hearing ends without a final sentence, leaving everything uncertain. The pre-sentence investigation will now play a major role because probation officers will review the defendant's background, behavior, mental health, and overall risk. The big question now is whether the judge will ultimately see rehabilitation potential or too much risk for leniency.